Okay, good afternoon and good evening to those on the East Coast. My name is Mike Bergen. I'm the Secretary Treasurer of Teamsters Local 166, and I'll be myself and Cliff Batham will be going through the Costco wholesale last best and final offer for you one more time. Okay, as a prelude to this, as you know, the International Union, International Brotherhood of Teamsters, has taken a neutral position on this contract. But as the lead negotiator in this particular contract, and I've been through a number of these, when you really analyze the contract as the company last best and final, I think we've gotten everything that's going to be gotten this time around in these negotiations. But not every local is in agreement with that, and some locals are taking a different stance on it. From my position, I back the position of the International Union of that as a neutral position, but I'm telling you, as a negotiator and in dealing with the federal mediation and the company in this last round of negotiations, I think that's all there is this time around. That being said, I'm going to go through the Costco wholesale last best and final offer for a renewed contract from 2022 to 2025. Under recognition, I'm not going to read the entire 3 paragraphs, but basically what it does is by bringing in Teamsters Union Local 210 for employees working in New York and New Jersey, Teamsters Union 570 for employees working in Maryland and Washington, D.C., and Teamsters Local 592 for the employees working in Virginia. They're going to be joined into the agreement, and this is going to become a national agreement, which it'll stay up in the top of the recognition. That is very important because that gives the bargaining parties unified negotiation strength, not only in the West, but also in the East. And the rules are going to be the same in the union location. Under Article 2 union membership, this is new language, and this is applicable only to the right to work states on the East Coast. And that says, in right to work states subject to applicable law, employees may become members of the union for compliance with this provision in any one of 3 ways. 1, by becoming a member in good standing by paying union initiation fee and other charges pursuant to the local union bylaws. 2, by paying uniform initiation fees and monthly dues and choosing not to become a member. Or 3, becoming a service fee payer, paying a percentage of the initiation fee and monthly dues based upon the amount of the union's collective bargaining expenditure bears to the union's total expenses. If the employee chooses to be a non-member service payer or to pay dues from the date following the 31st day from the commencement of employment or the execution date of this agreement, whichever is latter, any employee wishing to challenge the correctness of the union calculation of the service fee may do so. Information on the procedure to challenge the union's calculation will be made available upon request at the union office. Under union membership, under the drive language, the Democratic, Republican, Independent voter education, there were 2 language cleanups in there. The first one being shall notify the employer of the amounts designated by each contributed employee that are to be deducted from his or paycheck on they changed to week to weekly. That's the correct language. Basis for all weeks worked. The employer shall transmit to Drive National Headquarters on a monthly basis in 1 check. That language remained the same. Then in the second paragraph, there was a language cleanup also. The International Brotherhood of Teamsters shall reimburse the employer annually for the employer's actual cost for the expenses incurred. And the language said administering instead of administrating the biweekly payroll deduction plan. Under exclusion, the following employees will be exempt from union membership. Under assistant manager, that will go from 3 assistant managers to 4. Only change. Under the bargaining unit work, Article 2G does not apply to East Coast locations. This is the language that talks about managers performing bargaining unit work, and some of the exclusions that were excluded in this were managers of the meat, bakery, tire center, food service, deli operation, or merchandise area managers. Struck was photo manager and no longer applies. At new hire orientation meetings, we've added new language into that when the company has the new hires in there. We've always had language where they'll use reasonable effort to notify the local union of those meetings. We've added language in there that says union representatives and or a shop steward will be afforded time to speak briefly on behalf of the union. Okay. Then under authorization for deductions, modified language. Each individual Teamster local shall decide the initiation fee. Due structure for the lifetime of this agreement shall be determined in accordance with the International Constitution. That is 2.5 times the hourly rate of pay is the normal dues. Each local determines their own initiation fee. Under Article 4, right to discharge, that really goes on for a couple of pages and there's no changes until it gets to the excessive absenteeism language down at the bottom of page 4. And it reads, excessive absenteeism is absent from work for any reason for 4 unpaid occasions in any 12-month period, and will be subject to progressive discipline and or discharge if there's no improvement. Vacation, approved leave of absence, new language, holiday scheduled or unscheduled paid sick personal time, funeral leave and jury duty shall not be considered for purposes of calculating instances of absence. So if you have time in any of these areas, they can't ding you under excessive absenteeism for that time. That is described in Article 11H. Okay, now, new language and modified language. Absences caused by workers' compensation, injury, and treatment. FMLA, ADA, injuries and treatment were documented by a physician's note for each occasion, or SDI, that is used to extend FMLA or ADA. New language, state law leaves or other approved leaves of absences, or where otherwise provided by law, will also not be considered. Costco will not retaliate against or discipline employees for appropriate use of paid leave and or sick personal time. So bottom line is, if your absence falls under any of these categories, they can't ding you in the absentee program. Okay, there's no other changes for the rest of that page. You go to the next page, union representative. New language under Article 7, union representative shop steward. Under union steward at the end, new paragraph 5. In the event that a steward is on a leave of absence or otherwise away from work for an extended period of time, the union may appoint a temporary steward and will provide notice to management. So under holidays, Article 9, holidays, paid holidays, you see the normal 6 that we have. Change in language, or in addition to language, employees who desire to celebrate Martin Luther King's birthday, current language, new language, and or Juneteenth may request to use a scheduled paid sick personal leave at least 2 weeks prior to the holiday. the company shall extend every effort to accommodate that request. New language addition, annual floating holiday. Employees will be eligible for an annual paid floating holiday after 1 year of employment, which can be used for a cultural or religious holiday or day of observance or other day that is meaningful to the employee. On the employee's anniversary, if they have been paid 2,000 hours or more the prior anniversary year, then they will be eligible for 8 hours of personal floating holiday time. If they were paid for less than 2,000 hours, part-timers, then their available personal floating holiday time is prorated accordingly. Full-time hourly employees will receive an accelerated accrual for all hours worked on Sunday. Once available, an employee may take their personal floating holiday anytime during the anniversary year that is agreeable to the employee and their manager. This personal floating holiday must be used during the anniversary year it becomes available and will not be carried over to the next anniversary year. Hourly non-exempt employees will be paid out for their available and unused personal floating holiday at their anniversary and upon termination of employment. So that's an additional holiday that you can use at this time. And if you don't use it, you'll get paid for it. If you do use it, it'll be paid either as a full-time rate or as a prorated part-time rate. Okay, and then under paid sick personal time, I'm going to let Cliff go ahead and grab this.
Okay, and if I could just point out the, and I'll touch on it during the sick personal time, but in the holidays that were listed above, the East Coast will notice that the Easter holiday is no longer available as a set day. That is the annual floating holiday. And the East Coast also goes from 10 days to 11 days as far as sick personal time. We do have some good language, though, to make sure that the employees on the East Coast can continue getting paid for Easter and any additional days on top of that. So for this sick personal time, we're deleting the entire the entire article that currently exists, and it's being replaced with this. Subsection A, paid sick personal time. After 90 days of continuous employment, an employee shall be granted 24 hours of paid sick personal time to be taken in the first year of employment. After 1 year of continuous employment, employees shall be granted an additional 64 hours of paid sick personal time. Thereafter, on each successive anniversary, employees will be granted 88 hours of paid sick personal time to be taken during the year. Paid sick personal time is available for use and will be applied for any sick time absences. Paid sick personal leave may be used for personal time away from work. Paid sick personal time may be used for personal or family illness, injury, or preventative health care, reasons related to domestic violence, sexual assault, harassment, or stalking, school or child care closures by a public official, workplace closures, time lost due to a workers' comp injury, and other reasons authorized by law. Scheduled paid sick personal time may be taken for any non-sick reasons at any time that is mutually agreeable between the employee and their manager. Said time may be scheduled so as to afford an employee a long weekend or longer vacation. Employees must request scheduled paid sick personal time 2 weeks, but not more than 6 weeks in advance, in writing on a form provided by the company. The employer agrees to honor all such requests unless they are denied within 3 scheduled working days of that request. The 3-day period commences when the designated person or manager acknowledges receipt of request by signature and date. It's understood that an employee can only take up to 8 hours in any one day. And just a reminder, the language that says it needs to be, the time starts when a manager signs the document. If you just slip it into the schedule writer's box, time hasn't started. So protect yourself and protect your rights. Next, falsification of unscheduled paid sick time claims or proven abuse of unscheduled paid sick personal time privileges may be cause for discharge or disciplinary action. A doctor's certificate of illness may be required from any employee who is absent from work because of illness in the case of excessive absenteeism. Any employee who becomes sick and is unable to report to work shall notify their manager or designee 1 hour before the start of the work shift, except for the first shift of the day, which should be notified at that time by phone or a verified recording device on a direct line at the start of the shift, or as soon as reasonably possible. When possible, employees should make reasonable efforts to schedule planned paid sick personal time for sick time, example, doctor's appointments, in advance so as to not unduly disrupt operations. Absence is not covered by paid sick personal time. Employees who fail to report to work on a scheduled work day or leave work early for reasons listed in A and do not have sufficient paid sick personal time available to cover their shift will result in the absence being counted as an instance of absence or half absence. Consecutive unpaid absences are considered one continued instance unless broken by any period of work. Unscheduled absences will count as an instance of absence even if using vacation time. If an employee or family member becomes ill while they are at work and the employee needs to leave early, they must notify their supervisor or manager before leaving. Calculating use of sick personal time. Employees working in 2 classifications in a calendar week will be paid a blended rate for paid sick personal time taken during that same week. And just so you know, the blended rate comes into play mostly in those stalkers who work as forklift drivers temporarily during the week or filling in, but also it happens a lot on the front end. We have a lot of assistants who end up bringing during the week. If you do end up working both clerk and non-clerk positions, they will pay you the higher or the blended rate for that week. If the reason for the absence is FMLA or other protected leave, the employee may choose instead to use vacation or elect no pay for that time. FMLA, state law leaves, or other approved leaves and absences will not count as instances of absence except where otherwise provided by law. Sick personal time eligibility and amount. Subject to paragraph C below, full pay shall mean at the employee's regular rate of pay for those shifts which the employee would have worked had the absence not occurred, calculated at the regular rate of pay. Absence from work to up to 30 calendar days or 180 days for workers' comp within the employee's anniversary year due to sickness, injury, temporary layoff, or leave of absence shall be considered as time worked for the purpose of determining eligibility for the full 88 hours of the sick personal time for each anniversary year. In the event that the employee is absent in excess of the 30 days or the 180 days of workers' comp as set forth above, whatever sick personal time the employee is entitled shall be prorated according to the straight time hours actually paid, except that employees will always receive a minimum grant of at least 24 hours of paid personal time on their anniversary date. This last phrase essentially means even if you've been out of work because you broke your back last year and you missed the entire year, you're at least going to get 24 hours of paid sick personal time on your anniversary. Subsection C. Okay, lawyer speak. Here's a fair warning. There's some lawyer speak. Please don't fall asleep, but I will explain it at the end. Sick personal leave time shall be integrated with state disability and paid family leave benefits and workers' comp temporary disability benefits. So the sum of the daily sick personal time allowance hereunder and the aforesaid state disability or paid family leave daily benefits exclusive of the daily hospital benefits which may be payable to an employee shall not exceed 100% of the employee's regular daily wage at straight time. If the sick personal time pay allowance to an employee hereunder, when so combined with any such state disability, paid family leave daily benefits received by the employee exceeds 100% of the regular daily rate at straight time for any one day, then such sick personal time pay for that day shall be reduced accordingly. Any portion of the sick personal time pay allowance not received by the employee as reason of such reduction shall be retained in the employee's sick personal time bank as a part of their accumulated sick personal time. In order to effectuate the foregoing integration with the state disability and paid family leave, all sick personal time will be broken down from sick days time to earned as hours, and such personal sick personal hours will be used and retained as hours for sick personal time. Essentially, what that means is there are certain laws and benefits that the employees receive. Paid family leave and state disability are great examples where you'll get paid. You won't get paid nothing by the state. You'll get paid, let's say, 2/3 of your pay. What's actually taken out of your sick bank is the balance of the day. The rest of the money stays in your bank
Rest of the hours.
for the hours.
Correct.
Sick personal time payoff. Sick personal time allocated on the employee's anniversary date and not used during the following anniversary year will be paid off on the next anniversary date. Industrial injury. When an employee is injured on the job and is sent home by the employer or the doctor, the employee shall be paid for the balance of that day, but this will not be deducted from the sick personal time. There'll be no delay for sick personal time benefits. Sick personal time for part-time employees. Part-time employees shall receive prorated sick personal time based on hours paid to 2080. Sick personal time between the 91st day of employment and the employee's first anniversary, per Section A of the article, shall be prorated based on the total hours paid during this period. After the employee's first anniversary, sick personal time shall be calculated based on the 26 pay periods ending after the employee's anniversary date. Employees will always receive the minimum grant of at least 24 hours of paid sick personal time on their anniversary date. Sick personal time pay at termination. An employee with 2 years or more of service who leaves the employee of the employer shall be entitled to a payoff of accumulated and unused sick personal time and prorated portion of the sick personal time since their latest anniversary date based on the hours paid. There'll be no payout or accumulated or an unused sick personal time or prorated portion of the sick personal time for employees who leave the employer who have less than 2 years of service. The responsible use of paid sick personal time. Employees are expected to use their paid sick personal time responsibly. Abuse of unscheduled paid sick personal time may subject employees to discipline, but is not intended to infringe on an employee's rights to properly use sick personal time. The intent of the language is to allow for case-specific determinations of whether any abuse of paid sick personal time has occurred. The employer strictly prohibits retaliation against employees for using paid sick personal time for the reasons described in Section A. The company may take separate disciplinary actions for patterns of absenteeism and abuse of the attendance program. Patterns of absenteeism are defined as instances of absenteeism in conjunction with scheduled time off, weekends, or any other recurring events for 4 times within a 6-month period. Each situation will be reviewed on an individual basis with the opportunity for the employee to provide an explanation. Management will consider special circumstances such as non-consecutive days off that would make a pattern not subject to that discipline. An employee may be asked to substantiate that their use of unscheduled paid sick personal time was for a permitted reason. If it's determined upon review that there has been an abuse of sick paid personal time, then discipline may occur. The company will not discipline use of paid sick personal time for permitted reasons outlined in A or for reasons otherwise permitted by law. Costco will not retaliate against or discipline employees for the appropriate use of sick personal time. So the next section I'm going to talk about is the attendance, which was at the back of the contract in both East and West. And because it's been negotiated, we're moving the grid into the main body of the contract, as well as a couple of other things like the dress code and sexual harassment or the harassment policy. This attendance policy looks similar, but is different from our current plan. Under our current plan, you get 11 days and you could potentially be written up for using 9. You can get a verbal at 9, even though you have paid time left. Because of changes in law and the way we've negotiated our contract, we've actually gotten more more time for the employee after they've burned through all their sick time before discipline occurs. And it'll be as follows. When an employee is absent from work 4 or more unpaid occasions in a 12-month period, the employee will be subject to the following progressive discipline. So after all your sick time is burned, and they're not counting your FMLA time or other leave of absences, the first set of occurrences will get you no discipline. Same with the second, same with the third, but the fourth unpaid instance will be a verbal, followed by a written 1, a written 2 with a suspension, and the seventh unpaid instance will be a written 3 with suspension pending termination. So that actually gives the employees a little more breathing room the way it's set up, but we can answer some questions at the end if you have any. Under bereavement leave, we've modified the current policy to include extended family, and it'll be as follows. Article 12, bereavement leave. Leave for all employees shall be provided for the purpose of arranging and or attending the funeral as well as grieving the loss of a member of the employee's immediate family and or extended family. That's the new language. Bereavement leave for immediate family shall be at the straight time rate for the hours scheduled for each workday lost because of absence to a maximum of 5 days. Immediate family shall be defined as the employee's spouse, mother, child, father, brother, sister, stepbrother, stepsister, stepchild, current step-parent, pregnancy loss, and benefit eligible domestic partners. Benefit leave for extended family shall be at the straight time rate for the hours scheduled for each workday lost because of such absence to a maximum of 3 days. Father-in-law, mother-in-law, sister-in-law, brother-in-law, grandparent, daughter-in-law, son-in-law, grandchild, grandparents of your spouse. Verification of the time required for paid leave shall be supplied to the employer by the employee if requested. Employees will be provided with the same paid time off for their domestic partner's family. In addition to the above, the employee will be allowed extended time off without pay in extenuating circumstances or involving relationships other than defined above. Under classifications and wages, we've clarified a couple of things under the lead wage classification or premium. Paragraph 4 under lead wage premium will now allow the employee who is newly made a lead to go back not within 60 days, but within 90 days. As long as they notified management that they'd like to go back to their former position, they would be allowed to go back within 90 days. New language clarifies what happens to an employee when they leave the lead position. Paragraph 7 will read, leads who are reduced from the position either voluntarily or involuntarily may immediately be eligible to sign postings in accordance with Article 32, Section 2E, which is the posting policy.
Okay, you want me to give you a break?
Yeah, that'd be great.
Okay, very good. Okay, as we continue on, Article 20, working hours, overtime, and working in a higher classification. Under A, basic work week, we struck the current language in paragraph 4 and replaced it with, it is understood and agreed that the employer shall not replace a filled full-time position with a part-time position except as defined in Article 21B3. The company reserves the right to evaluate the need for full-time or part-time replacement when a position is vacated. A modified language as openings occur. Full-time employees and the top 20% of part-time employees will be given their choice of work week by seniority in accordance with Article 32(2)D. The guaranteed minimum work week. This is for the East only, and it replaces the first paragraph. All regular full-time employees shall be guaranteed a minimum week's work of 40 hours exclusive of lunch period. Employees who normally work Sundays as part of their regular schedule of the regular work week through mutual agreement may work fewer hours on Sunday and be paid for actual hours worked. Employees volunteering to leave early will be paid only for the actual hours worked on that day. The remaining paragraphs, 1, 2, 3 remain the same. New language: when a department undergoes a planned renovation, the employer will make reasonable effort to limit any disruption to the affected schedule. Under promotions and demotions, under promotions, part-time to full-time, in the event a part-time employee works 40 hours in their own department or regularly scheduled in the same combination of departments or 38 hours, including Sunday, or more for 8 consecutive weeks, the most senior part-time employee in the same classification in the department will be offered the full-time position. And said full-time position shall continue to be offered by seniority until the full-time position is filled. Paid sick personal leave, vacation, and holidays shall be counted as time worked. The employee must work in the schedule where the hours were created for 3 months, down from 6 before they can rebid. Okay, under 2, service assistant to service clerk. If a service assistant accumulates a total of 800 hours worked in the service clerk bracket in the prior 26 consecutive pay periods, the most senior assistant with the same status in the department shall be offered a promotion to service clerk, and said service clerk position shall continue to be offered by seniority until the service clerk position is filled. Under demotion, there was no change. Under posted voluntary demotion, there was an add to an asterisk. Go down below that paragraph. The language remained the same except for the asterisk. And this applies only to local 210 jurisdiction. An employee who is granted a voluntary demotion to change their status from full-time to part-time will be placed on the front end according to company seniority. Such employee may bid new openings as they occur. The vacated full-time position shall be a posted position unless such position is being eliminated by the company. Under section 3, full-time to part-time, the first paragraph remains the same. And then for East Coast locations only, should a full-time employee average less than 34 hours for either the first or second 13 pay period, 6 months, their status shall be changed to part-time. Vacation, holidays, sick personal leave, funeral leave, jury duty, absences caused by workers' comp injuries, and treatment of absences pursuant to the Family Medical Leave Act were documented by a physician's certification will not be considered. Under work schedule, for the scheduling, on the Monday 2 weeks prior to the scheduled work week, the schedule will be posted no later than 12 p.m. Such schedule is normally produced by the computer and includes the employee's name, starting and ending times, and days off. New language: effective July 4th, 2022, the schedule will be posted by department / sub-department seniority. New language: the written posted schedule is the controlling document, and other electronic documents are only for the convenience of the employee. Important language: once the work schedule has been posted for the succeeding week, such schedule shall not be changed except on 48 hours notice to the employee affected in person or by phone. So now they got to come tell you, and they've got to do it 48 hours prior to. Under miscellaneous, with post-accident testing, you may be subject to post-accident testing if you're involved in a serious forklift accident exceeding $3,000 in property damage. And at that point, you may be required to submit to drug and alcohol screening. The previous language said you will be, it is now subjective and may be required. Under temporary layoff, rollback to job discontinuance, reduction of job discontinuance. This is talking about the testing. If an employee is bumping into a position that requires minimum testing performance or prior job knowledge, i.e. including inventory auditor, maintenance too, bakery or meat cutter, and had hearing aid assistant, that has been removed. And then otherwise, the employee shall be required to meet those standards. Okay, under the seasonal language, all tire centers shall have a seasonal period from May 1st through September 15th of each year. Leaves of absence, the current under subsection A, under pregnancy, that language has been deleted. And for consistency and compliance, new language has been put in for pregnancy and associated leave. The employee must provide her manager with written medical substantiation from her physician. Leave for bonding will be granted within the parameters of the applicable state leave act and company policy. Cliff, can I get you to go for a couple?
Not a problem. So under seniority, there were a few minor changes. Currently, if an employee under the application of seniority under transfers between any Costco warehouse in the US. As you know, if you transfer from union to union location, you lose no seniority. You have your full seniority from day one. This clarifies that there is a 6-month hold on non-union transfers into a union building for the West Coast locations and 3 months holding back the seniority on the East Coast. That was the merger of the two language articles we had in both those contracts. In bidding for job openings, typically, well, for the last 40 years, you've had to be available to work the posting for 6 months. Now it's only 3 months. So employees applying for a position must agree to meet all requirements, including availability for a minimum of 3 months, and agree to be in the position for a minimum of 3 months. If the employee that receives a job bid returns their old job within 60 days, the company may then award the next senior person qualified in the original bid sheet without the necessity of rebidding the same job. The 3-month restriction shall not apply where changes of hours or scheduling within the department occur, which means a rebid, or the ability to move from part-time to full-time and or service assistant to service clerk. Postings shall include the days off, designation of opening, mid, or closing shifts, and an example of the shift. If that posting is not specific, then the employee can exercise their seniority rights to obtain an earlier start time after 30 days in the position. Also, we've added a clause that the employer will notify the union of the awarded posting, as well as verbally notify the successful bidder within 7 calendar days. Towards the back of the contract, we have the appendices, the different appendices under the delivery business center program under section D for bidding, and this is for truck drivers. When for any reason an employee transfers into a business delivery as a delivery driver, said employee will maintain seniority for all purposes except for route bidding purposes, for which the transfer end date will be the effective date for route bidding. And this is an industry standard, and it has been for 50, 60, 70 years. This just falls in line with what normally happens. This next section right here was one of those policies that were in the back of either the East or West Coast contracts. We have negotiated it. The language has changed, and now it'll have its own article in the contract. And this is the Anti-Harassment Policy. All verbal, physical, and visual forms of harassment for employees, applicants, independent contractors, members, guests, and suppliers is prohibited. All forms of harassment based upon race, color, national origin, ancestry, sex, including pregnancy, childbirth, breastfeeding, and any related medical conditions, gender, sex stereotyping, sexual orientation, gender expression, gender identity, transgender status, religion, age, hairstyles or hair texture commonly or historically associated with race, mental or physical disability, medical condition, work-related injury, covered military or veteran status, political ideology or expression, genetic information, marital status, citizenship status, the protected status of anyone with whom the individual associates, or any other protected status is prohibited. Epithets, slurs, negative stereotyping, or threatening, intimidating, or hostile acts that relate to any of the above mentioned protected groups are prohibited. Written or graphic material displayed or circulated in the workplace that denigrates or shows hostility or aversion towards any of the above mentioned protected groups is prohibited. Sexual harassment is prohibited. Sexual harassment is unlawful sex discrimination under federal, state, and local law. Sexual harassment on the basis of self-identified or perceived sex, sexual orientation, gender expression, gender identity, and transgender status is prohibited. Sexual harassment includes unwelcome conduct that is of a sexual nature or that is directed at an individual because of that individual's sex. When the conduct has a purpose or effect of unreasonably interfering with work performance or creating an intimidating, hostile, or offensive work environment, even for one who is not the intended target of that harassment. Sexual harassment also occurs when the unwelcome conduct is made either explicitly or implicitly a term or condition of employment, or submission or to or rejection of the conduct is used for an employment decision. Sexual harassment can occur between any individuals regardless of sex, gender, or sexual orientation. The parties agree that this policy also prohibits sexual favoritism. Sexual favoritism occurs whenever an employment decision is based on an employee's receptiveness to sexual advances. Sexual harassment is not limited to the physical workplace. Sexual harassment while traveling for business or at Costco events is prohibited. Calls, texts, emails, and social media usage can be workplace harassment even if they occur away from the workplace, on personal devices, or during non-work hours. The reporting of these types of harassment. If an employee believes that they are being subjected to harassment, discrimination, or retaliation, or becomes aware of such conduct being directed at someone else, or if an employee believes another person has received more favorable treatment because of discrimination or sexual favoritism, such incidents should be reported to a manager or above, as outlined in the open door policy, or via the Ethics Point site found at www.costcoethicspoint.com. This applies to harassment, discrimination, or retaliation caused by anyone with whom the employee may come into contact as part of their job: managers, supervisors, coworkers, members, independent contractors, suppliers, or others. All reported incidents will be investigated in the manner determined most appropriate based on those circumstances. Employees can also make a report in writing and provide documentation by mail to the confidential submission. The address is right there on your screen. The Code of Ethics requires that we collectively obey the law, and the company encourages the good faith reporting of unlawful or unethical activity. Anti-retaliation policy. Retaliation for those who use the open door or who otherwise report violations of Costco policies or laws is prohibited. Retaliation includes any action that would discourage an employee from reporting violations of Costco policy, using the open door policy, or participating in an investigation. If an employee believes that they or another person has been the subject of retaliation, they may report the matter to a manager or above through the open door policy or through Ethics Point. Any employee found to have violated this anti-retaliation policy is subject to corrective action up to and including immediate termination of employment. Corrective action will depend on the severity of the offense. The dress code is another one of those policy issues that was renegotiated and stuck in the contract. It will have its own article, and it is as follows. And it's a lot briefer than the previous policy was. Employees must ensure that their appearance is neat, clean, and professional, and must practice good grooming and personal hygiene habits. Costco permits employees reasonable self-expression through personal appearance, which includes hair color, moderate piercings and jewelry in permitted departments, and visible tattoos. Costco will allow visible tattoos, piercings, and jewelry unless they contain images or words that are obscene, profane, racist, sexual, depict violence, or are otherwise objectionable. All attire and accessories worn in the workplace must be free of any advocacy messaging. Advocacy messaging is defined as supporting or recommending a particular cause, public policy, or political party. Accessories include, but are not limited to, stickers, buttons, pins, lanyards, belt buckles, face coverings, hats, scarves, jewelry. The following categories of workplace attire will continue to be permitted. Company issued or otherwise approved Costco wholesale writing or logos related to company approved charitable initiatives, sports team or collegiate apparel, other company approved special attire events, sportswear or fashion brand logos, and of course, union apparel. For safety reasons, employees are prohibited from wearing open toe or open heel shoes or sandals in the warehouse. Employees will be required to wear composite steel toe work shoes and slip-resistant shoes as directed. And this goes for both union, non-union managers and non-managers. Name badges must be clean, accurate, and easy to read, with only company-approved attachments. But note, if an employee has specific questions regarding appropriate attire, they must ask their location manager in advance. Inappropriately dressed employees are considered unsuitable to commence work and will be sent home. Employees may be asked to return to work later the same day in attire conforming to company standards. Employees required to leave due to inappropriate attire will not be compensated for any lost time. Employees may also be disciplined if they arrive for work inappropriately dressed. The next set of changes are fairly minor. It's mostly housekeeping, but it addresses the no call, no show, late calls, and they were moved out of the majors into the minors, and they're as follows. Minor 20, failure to begin your meal period no later than the end of the 5th hour of work. This was modified so that 3 separate failures in a 30-day period is considered excessive. So it might happen once or twice, but the third time in the month, they'll ding you with it. Minor 21, no call except in emergencies, failure to call out within 2 hours after the start of the scheduled shift. Minor 22, no show, failure to report for a scheduled shift within 2 hours of the start of the scheduled shift. 23, failure to call out at least 1 hour prior to the start of the scheduled shift or at the start of the shift if this is the first shift of the day. And under majors, we struck out number 22 because it's addressed above. There are a few letters of understanding I'll go over. The first one being the combo classification. As of February 1st, 2022, it'll be recognized that the combo is not a contractual posting or position and will no longer be utilized for scheduling or posting provisions. All current combo positions shall be reassigned to a specific home department, and the employee will be eligible to utilize their seniority under all provisions of the CBA. Temporary managers. This is a new concept for us that we got during the pandemic. The company may utilize union members on a temporary basis to perform work as a temporary manager. The union member must replace a specific identified manager who is out on a leave of absence and will not be able to perform bargaining unit work unless allowed in the agreement. The temporary manager will remain an active union member, work in their home warehouse, and not have the ability to hire, fire, or issue discipline. Management will notify both the local union and labor relations in writing of who is affected, who and what position is being replaced, and the start and anticipated end date. The parties will meet no later than 90 days from the execution of the letter of understanding to discuss the duration and number of managers over the agreed upon duration of time. The next letter of understanding, I believe, was in the East Coast, but not spelled out in the West Coast. It's a lot security premium that those employees who are doing lot security using their own vehicle, they'll get $1.50 for it an additional $1.50 an hour, but you have to job transfer at the clock for that. The letter of understanding for the cameras has not changed. It's been in the contract for about 20 years. The language hasn't changed. The cameras are still there. The current letter of understanding that you see stricken out on the screen, there is this deals with strictly the drivers in the Bay Area, Hayward, South San Francisco, and San Jose. There will be another letter of understanding clarifying certain provisions for that work group, but that will not be voted on during this contract as it's still being negotiated. We've stricken some language out of a letter of understanding out of the contract. This is old language and just it was there for historical purposes only. This next letter of understanding specifically talks about the switchover from the current policy, the current attendance policy, to the new policy. When it happens, what happens, how are the employees protected, etc. The parties agree that the current attendance policy will be modified to the proposed attendance policy on January 1st, 2023. At that time, all current instances of absenteeism, meaning any sick days you have on record, and any discipline that might be associated with them, and that's for your verbal, your first written, your second written, your final warning, will be removed from the employee's file. And the employees will start with 0 instances of absenteeism on that date. And just to clarify something about the attendance policy, because I don't think I mentioned it earlier, the employees will continue earning the policy, continue earning sick time in the same way we have over the last 40 years, 50 years. It's not earn as you go, which is on the, you have to work 30 hours before you get 1 hour of paid time. It's all dropped on your anniversary and it's for you to manage for the entire year. This next paragraph is a new article, but it's critically important to the language in the contract, and it's actually a very big win. I'm going to pass this back to Mike Bergen so he can explain what that is prior to going into economics.
Thank you. This is what's called the favored nation clause. Normally you see this in master agreements where you have other entities doing the same thing. But in this particular case, we had to take this on the company because if you remember correctly, what the company did is after they put the last best and final on you guys the last time at 75 cents, then they tried to slide the pickle in with the 50 cents while we were still out to vote. Okay, we went back, got that after the turn down. But what this language does, if they try that stuff again, where they try to give something better to the non-union than what the union has, the union gets it automatically. And I'll give you an example of that as we speak about the pension and 401k. But the language reads this: the employer agrees during the term of this agreement. Hold on, I got a jet going over. Cliff, you better do it.
No problem. The employer agrees during the term of the agreement that should it grant more favorable economic terms to its non-bargaining unit employees, then such more favorable economic terms shall be offered to the union at the same time and in the same quantity as they were granted to the non-bargaining unit employees. Any dispute over the meaning of this provision, including but not limited to whether the non-bargaining unit increase was more favorable than the economic terms in effect for the bargaining unit employees, shall be resolved by the grievance and arbitration procedures as provided by in this contract.
Okay, and basically, here it goes again. Basically what that does, if they try to do anything that's more favorable to the non-union, then they have to sit down and tell us, and we have the right to it. So that's going to become important a little later on when we talk about the 401k as an example. on the match on the 250. They can't. It has to remain, even though it's been removed as a contribution. It still has to remain because it doesn't change in their summary plan description. And as long as that's there, you're going to continue to get it. But that's going to become a favored nation piece. So this is very, very important language. So as an example, a question came up on the at the last session. Well, what about retiree coverage? Well, neither side has retiree coverage at this point. But let's say the company tried to give retiree coverage to the non-union side. We could invoke this language and force them to give it to the union side also. That's what that language does. It's very, very important language. Didn't cost them anything yet, but if they try to do anything to improve the non-union without offering the same to the union, then they're going to have a problem. Okay, and with that, let's go on to the economics. Okay, economics, pension, and wage increases. We're going to start out with the pension. Okay, the pension contribution increases over the life of the agreement will be 40 cents per hour effective back to February 1 of 21. An additional 15 effective February 1 of 20, excuse me. Effective February 1 of 22, 40 cents. Effective February 1 of 23, 15 additional cents. Effective February 1 of 24, an additional 15 cents. We got that 40 cents because we traded off the $250 in the 401k that the company gives you. And I did some numbers for the last group because it was asked, well, why did you do that? And here's why. The number became worth this. If you take the 40, 15, and 15 over the 3-year period, that's a contribution of $3,432. If you take the $250 a year, that comes out to $750. You can put $750 in out of your own tax deferred if that's what you want to do. But the money you're taking in the pension continues to grow year after year because that match goes on year after year. So that's why we did that. So the first year pension increase reflected the Teamsters request and cost of agreement to end the 401k match program for hourly employees. But they can't do that until at least January 1, and their board has to do that through the through a summary plan description change, which would allow them to do that. They can't do that right now. So we will hold on because we'll probably try to invoke the favored nation based on that. And I know there's a manager on this call, so I'm sure he'll go running back upstairs to let them know that they stepped in the kimchi again. Okay, under the pension on the next couple of pages, it shows what the old rate was and that's struck. So you go to the top of, or you go to page 22, it talks about effective February 21 of 22. Okay, that is going to be retro. The employer will go back and pay all the appropriate hours at $1.81 per hour for each hour worked. And that'll be a basic contribution of 69 cents and 12 cents to the peer. Okay, then effective the first payroll period in February 1 of 23, that rate then goes up to $1.96 or 183 into the basic and 13 into the peer. And then effective the first payroll period after February 1st of 24, they kick it up another 15 cents to $2.11 with a basic contribution of 197 and a 14-cent peer. Okay, so that's going to be your pension increases. That's a very healthy increase for a pension. The language on the next 2 pages is existing language. or the top of the next page. Then we go into the wages. Okay, the B1 chart shows all of the different rates for the people that are in the tiered rate. And it demonstrates the 50 cents that they got, or they'll get retro back to 2/1 of 22. Okay, so that'll be retro in your area. For service assistant, it shows the increase of the 50 cents back to 2/1 of 22. It does it to all four of the areas, and it shows that they'll get the 50 cents back. They move it forward, and their goal hours will not be reset, so you'll continue to move forward. Okay, at the top of scale, which was where the issue was, you're going to have a couple of different changes here. So this rate shows the top of the rate scale effective 2/1 of 22. It'll go up the 75 cents to 26.25 for service assistance. It'll then go on going back retro to July 1. It'll go up another 50 cents, and you'll get that money up to 26.75, and then you'll get the 60 cents, I think it is, on February 1st of 23 to 27.35, and of course the 60 cents 2/1 of 24 to 27.95. You carry that all the way across, and it shows each of the top of end scales getting first the 75 cents, then the 50 cents, then the 60 and 60, and that's what their top outs will be. If you go look at the asterisk in the last chart on the truck driver, that also included a premium of $3 that's in some of their letters of understanding. If you go down the chart, you get the breakdown on the dates, basically saying the same thing. On 2/1, you go from the 20, you go the 75 cents. 7/1 of 22, you go the 50, 60, and 60, and it follows down and shows what those rates are going to be. Okay. Under the Appendix D Premium, employees who either drive a forklift or an electric pallet jack will have their rate reflected back by a $1 per hour premium, retro back to 2/1 of 22, in addition to their normal rate of pay. For the pharmacy technician premium, they also will go back to $2 an hour, back to 2/1 of 22. Now, the question that this raised, and I brought it up in the first meeting, was, well, what about the leads? How does that affect the leads with this premium with the retro? I presented that question to Richard Areola, and he hasn't gotten back to me yet. But the leads are supposed to get X amount above the highest rate lead. If in fact they've changed these retro back, they may possibly have to change the leads back and owe them some more back pay also. Then we go to the Appendix B, extra checks. You'll see the changes in that. That will also be another retro piece because we're in October. You're going to get the previous extra check. But if this passes, then they'll go back and they'll have to pay on a separate check the difference between the retros because it's at a different tax basis. Okay, then you go that on the 2 pages. You have the service assistant, and then you have the service clerks on the back page. That being said, the last page is the continuing extension of agreement, which is still in effect and goes and will remain in effect until after the count of this contract. Now, that is the company last best and final offer. And again, the international union has taken a neutral position on it. But again, I have a responsibility as the lead negotiator to tell you that in my experience, in this particular case, I think that's all there is. I don't think there's any more. The ballots are out. You're going to be receiving the G code or whatever it's called in the mail. You go on that and you go vote. A yes is to accept, a no is to reject. If it's rejected, it's an automatic strike authorization vote. Okay, and with that, I think that's the presentation. I'm willing to answer any questions you may have.
Mike, let me just point out too, if you or any of your coworkers have misplaced your balloting information, you may have moved somebody in the family accidentally threw it out thinking it was junk mail, your dog ate it, whatever the reason, get a hold of your business agent. There's somebody in your local who can recertify you. It doesn't take a long time. It's just a matter of a few minutes, and the third party administrator will email you or text you, whatever your preference is, the new secret code so you can call in or log in to vote. And
yeah, call your local union, and they've gotten the signed person that's going to do nothing but the recertification.
Are there any questions out there? If so, there is a raise hand feature on your screen. Okay, we have one question from Javier. Javier, please unmute yourself.
Hey guys, I know I asked this earlier the meeting, but I know that Mike mentioned that if we vote a no vote, it's an authorized to go on strike, but not necessarily correct. They can go back to the table and actually negotiate.
That is correct, Javier, and that's a great question, and you're going to get the same answer you got before. Yeah, that does authorize us to strike. However, what we would probably do is go back and tell the company it was turned down by a majority of the people, and they then have to make a decision on whether they want to go back to the table. And we would request that, of course, that they would want to go back to the table or basically tell us to take our best shot. But I have a responsibility to tell you that, because of the changes in the international constitution, it's no longer a 2/3 majority for a strike vote. It's now a simple pass or fail. If it passes, you have a contract. If it fails, that also authorizes the strike, and we have a responsibility to let you know that could be the immediate result. Although the normal protocol is we would go back to the table with the company if they're willing to go back.
So basically, that 2/3 that was removed, I think that's according to what I understand at Costco, which is kind of a little misleading, another a misunderstanding from all of us. But we used to think that a no vote was a yes vote, and so now that they've removed the 2/3 vote, no longer does that exist.
That's correct. It's a straight up and down now. What the previous language used to say, if less than half the people vote, it must be rejected by 2/3, otherwise it was an automatic contract. Now it's just a straight yes to accept, no to reject. We have an obligation to tell you that a no vote authorizes the strike, authorizes the strike authorization.
Okay, guys, if you've got any questions, the little happy face down below, all you gotta do is click on it and raise your hand.
Pam, please unmute yourself and fire away.
I can't hear anything.
Can't hear you yet. Check on your toolbar. There is a mute and unmute. There we go. No, not quite yet.
Not yet.
Well, Pam, keep your hand raised. Look for that. We're going to take the next one from Amanda Valenzuela, and we'll come back to you. Amanda, can you unmute? Thank you.
Can you hear me?
I
Yeah.
can.
Okay, so I have a question on Article B1. So on here, it's showing for the part-timers, their guaranteed raises for an employee that just started or is not topped out yet. From what I'm seeing, it's gonna take them about 5 years for them to hit top pay. How is that? Like, I don't agree with that.
Okay, well, that's fine. That actually goes back about 30 years on how they've done that. Now, that was based on a progression rate that was put in back in the Price Company days. And what they've done is they've added to this over the years. And basically, it's a progression that you go. As you work the hours, you then step up to the next progression. As back in the day, they had mainly part-timers in there. That's why we had to put the ratios in there, that they could only have so many part-time, because they got so many kids in college and stuff that they didn't expect to stay for 30 years. And now they have, but they've gone through this. This is no different than other contracts that have progression rates. At every 600 hours, you get an increase, or every 3 months, that type of thing. That's the progression. This happens to be, if you work more hours, you move through it faster. But it is a common progression rate. In fact, it's actually in the food industry itself, although ours is much better than theirs.
Yeah, so my other question is, a lot of part-time employees have fell behind on their raises. So from what I heard on this one is you guys are not allowing them to reset the hours when we get that 50-cent raise. In the past years, they have been resetting our hours, which makes us lose out on our raise. For example, last contract, we got 50-cent raise. Some people were at 10 hours to hit their next raise, and their hours were reset. So it pushes them back on their raises.
Well, on this now, whatever hours you have works towards the next increase, as I understand it. That's
Yeah,
why
so as of now, yes, it is going, they're not allowed to reset the hours on this one, but what about, I mean, I kind of feel that the hours for part-timers should be lowered to hit for the next raise.
well, I'll be frank with you. We can't go back and fix the wheels of time from yesterday, but we can go forward on the thing, and that's what we're trying to do. Part of this was driven by the need to move people up in the progression rate because of what they did. In my opinion, this is my opinion only, because of what they did by moving the minimum rate up so high and not really taking care of everybody in between, including and especially the top end people. So this kind of gets us a little step forward and balances that out a little bit better. Did you hear that, Alondra?
Yeah. Yeah, I was able to hear. Okay. So on another question, are guaranteed, for example, for part-timers, it's 64 hours of paid sick time. So I heard you're saying guaranteed. Is that guaranteed automatically, or do we have to accumulate hours to get our sick time hours?
No, based on the amount of, if you're a part-timer, based on the amount of hours that you work in the previous 26 pay periods, I think it is, they go back, and at your anniversary date, they give you credit for that prorated amount of time, not to exceed 88 hours, but no less than 24. That's a roundabout answer to that. So it is a pro rata, but it's on an annualized basis rather than a 2.3 hour per work week type of. That was really more like a PTO program than a set rate hour program.
Okay, so one last question on that. so it's hours worked, is that including vacation time, personal time, sick pay that you've taken? Is that
That's right.
accumulated with it?
Yes, ma'am, that's considered hours worked.
Okay,
And there's some leave of absences in there also that become issued as hours worked. But again, no less than 24 hours will be granted to any person.
okay. And then for FMLA, does it work the same to hit the hours?
It's a part of that, yes. I think that was talked about in there.
Mike, if I could, because I was dealing this at my local, the vacation hours don't count towards your FMLA.
That's correct.
Yeah,
Okay.
but the rest of the time does.
Yeah, but that becomes a different pro rata.
Yeah, okay. Okay, that was my last question. Thank you.
Great question. Thank you.
Yeah.
Next.
Javier, if you can unmute yourself. Just on the accrual hours on the sick call, what if you were injured at work? Do those hours count towards your PTO?
I think it talked about an integration with STI illnesses and injury. So if they're going to take your time to integrate with STI illness or injury not to exceed 100%, they can only reduce it by that much, but then that becomes compensation. Therefore, that's counted towards your recalculation.
Thank you.
Some of it gets confusing. You have to think about it for a second.
And you know, when we're done with the call, that's not the last opportunity you have to ask questions.
Correct.
Tackle your shop steward, tackle your business agent when they come, call them on the phone. Call them, say, hey, when are you coming in? There are a few people in merchandising or in our food court who have questions. We want to make sure we are voting the right way, or we have a better understanding before we vote. So please reach out to those people.
Okay, other questions?
Javier, please unmute yourself.
And as far as like the strike, the authorized strike, let's just say that we end up going into a strike, or for perhaps Costco decides to go back to the negotiating table, and you guys can't come to an agreement, and then you guys pull us out to a strike. Can you explain the economic strike? Because I believe that came up before, how that works.
Well, for you, they all become an economic strike. The power of the strike, there's really no difference in the two. You're not usually going to take a company out on strike over language. It's normally going to be over money, unless it's such a crazy company. And I think I referred to a couple of them in the food industry. I think Super Value was one of them, and Cisco Foods, I think, was another one, who the International currently has out on strike. Those are economic strikes. Those are over money. Okay, I'm going to be very, very loud and clear to you. Okay, I wanted $2 an hour for the top end people. That would have been appropriate to me. We didn't get that. But is that worth striking over? That's what you got to think, especially when we're already almost a year into this contract period. Or are we better off preparing for the next period of time, which would be 25, and having all of our ducks in order then? The company will know we're coming after them. They know we're hot on their tail now. But what is better for you? Because we've heard all the stories already. Well, the part-timers can't afford this. The full-timers don't want to. The other ones do want to. If you walk out as one. If you walk in together. That's the effectiveness of a strike. That becomes an economic strike because you strangled their economic source that you're trying to take more money from. Okay, but I'm going to tell you straight out, it doesn't do any good to have a shutdown strike in Marietta and have 30 stores around it working. Okay, we can get their attention because we're hitting them in the head by doing that, but that's not going to get the job done. This is a multi-billion dollar company that's international, okay? But at the same time, they have an image that's very important to them. I have people with 30 years there that have worked their ass off during the pandemic that I think are being shortchanged. But is this to fight? Is this to fight over a couple of bucks? And hear me out, over a couple of bucks right now, okay? Or is the real fight 2 years from now? And that's something you guys are going to have to think. I came out of the freight industry. We used to strike every 3 years, come hell or high water. Hell, we had language where we could walk out for 48 hours once a year. And we used to abuse that. You got to pick your fights today, especially when you're taking on a behemoth. And that's what you're doing. Okay. And if you do it, you have to do it across the board together. And you have to know that you have the numbers in order to do that. Okay. You know, I would have liked nothing better than to get the $2 an hour. But again, I have to be honest and say, I don't think that $2 is there. Based on the way the negotiations went with the federal mediator and the company in there, the $2 wasn't the future. We did get additional stuff. We have a better contract than what they offered the first time. We have a contract that's far superior to what they did for the non-union. We've got language in there now that will stop them from trying to put the non-union ahead of us when we've always driven the trade and they've gotten what the union has gotten because we've negotiated for them when we negotiate for you. So pick your fight. Pick your fight. That's all I say.